Every company, when we start with the statutory meeting, every company limited by shares. Now, what is a statutory report, sir? Shall be discussed here. This is very, very important. This is mandatory for all of us to understand, where you are going to discuss the performance of the company over the past year. Respective shareholders of the company. This is mandatory so that they make it. Good morning and welcome to the session 4 of Unit 4 in Company Law, where we are going to speak about the company meetings. Now, why company meetings are very, very important? What do they really mean for a company? Let's go and see. Now, there are 4 types of meeting that we are going to talk about. We are going to start with statutory meeting, annual general meeting, extraordinary general meeting, and class meetings. Now, all these 4 meetings are very, very important because the concept of meeting is to convey something important to the shareholders as well as to the people. Now, moving forward, every company, when we start with the statutory meeting, every company limited by shares and every company limited by guarantee having a share capital shall within not less than 1 month and not more than 6 months shall conduct a statutory meeting with the respective shareholders to hold a general meeting, and this is called as a statutory board meeting. Why? Because this is the first time the company will be meeting the public. Now, this is a mandatory clause that you need to understand from the perspective of company law. So today I have started a company which is a public company limited by shares. So after the commencement of my operation, that is before 1 month, after the commencement of 1 month, not before 6 months, not later than 6 months, I will not go forward and I will not delay this process, but I have to conduct a meeting where I will call all my shareholders and make a general body meeting. This is the first appearance for the company where they will come out, they will talk to the people, they will tell what are all they have been doing, what is their performance, what is their ideology, all those factors will be listed here. So this is where I would say that the company law says that it is mandatory for a company to come out, tell the public what they have been doing, why they are conducting a meeting, what is the purpose, what is the objective, who are all the key people, how we have taken up the project, how we are planned to execute it in the coming years, and what is our performance altogether. This is the platform through which they are going to discuss this entire factor here. Moving forward, the statutory report. Now, what is a statutory report, sir? The board of directors, at least 21 days before the day on which the meeting is to be held. Now, let's say that the meeting is going to be held on 30th of December. That means 21 days prior to this, right? So 21 days prior to this, what they need to do, they have to forward a report called as the statutory report to every member of the company. So by 9th December, they should have forwarded the statutory report to every member stating that what are all has happened in the company over the past few months. This report is mandatory. Why? Because that will tell them an bird's eye view of the company's performance. This will also tell the procedure at the meeting, list of members, discussion of matters relating to formational aspect, adjournment. So all the protocols of the meeting shall be discussed here. This is very, very important. This is mandatory for all of us to understand and to know. Followed by the annual general meeting. Company to hold an annual general meeting every year. Yes, the company will hold an annual general meeting. Every company in each year shall hold it in addition to any other meetings, a general meeting, as its annual general meeting specified. Now, if you see here, what will be the case is that the company shall call for an annual general meeting once in a year. Now, that annual general meeting is very, very important. We call it normally as a general meeting. But then why this annual general meeting is that? Because that is the most important meeting where you are going to discuss the performance of the company over the past year. Now, that is the largest general body meeting where each and every shareholder of the company shall come for the meeting, is given an open invitation to participate, to raise the queries and opinions about the company. There shall not be more than 15 months between one annual general meeting and the other. But the first annual general meeting should not be held within 18 months. That is, it is mandatory to be held within 18 months from the date of incorporation. So within 1.5 years of the incorporation of the company, it is mandatory for you to go ahead and start listing up your annual general meeting. If it is not done, then as per the company law, the company can be fined. The company can be fined a lawsuit against for doing this particular action. Now, the registrar may, from any specific or special reason, shall extend the time for holding an annual general meeting by a period not exceeding 3 months. But no extension of time is granted for holding the case of the first annual general meeting. So that is very, very important here. Now, the registrar may say that you may extend the time. Okay, there might be cases where I will give you the extension of time so that you can go ahead and conduct the annual general meeting. But at any point of time, this cannot be completely taken off. You have to conduct the annual general meeting as prescribed so that you are able to convey all the important matters to your investors and to your board of directors. Followed by the requirements of an annual general meeting. What are the requirements? The first thing is, it is a statutory requirement. Now, let us see. The annual general meeting of a company is on a statutory. It is called even when the company did not function during the year. Cancelling or postponing of the convened meeting. This can be when an annual general meeting is convened for a particular reason. The board of directors, the shareholders shall be intimated well in advance. It has to happen on a working day only. On any government holidays or national holidays, you cannot hold a annual general meeting. At the same time, if there is going to be any cancellation, you need to give a bona fide reason for that. Suppose if it fails to hold, then you have to, any member there can have to apply to the company law board for calling the meeting. You have to say that, sir, this is the reason why we have failed. These are the factors. So we will conduct the board of meeting in the coming days. The company and every officer who is default will be punishable with a fine if you have not conducted the meeting. Now, the powers of company law board call an annual general meeting if it makes it mandatory to call for the annual general meeting. Then the company, every member of the company has to be present and they need to understand this call and conduct the general body meeting. Followed by the penalty for the default. If the company makes a default, holding the meeting of company law, that is in default, if it is not being done properly, if it's not done according to the direction, then every officer who is involved in this company, every member who is involved in this company is definitely going to be punishable under the Companies Act, under the law altogether, and they have to pay a penalty for that. Moving forward, let's talk about something called as the class meetings altogether. Now, what are class meetings? Under the Companies Act, class meetings of various kinds of shareholders and creditors are required to be held under different circumstances. Now, for example, there might be a class meeting regarding an appointment. There might be a class meeting regarding an extension, a diversification, or there might be about a small governance issue, or let us say about a remuneration issue, or about some new name change. So there would be class meeting for different shareholders, and whatever the rights attaching to these shares, whatever the duties and factors that are being attached to that can be varied. And these class meetings are not really mandatory that every time it has to be notified, it has to be brought in presence. But yes, with the approval of the company secretary and the board of directors, every class meeting should be documented and sent to the corresponding authorities so that they make a note of what is happening in the company. Followed by the extraordinary general meeting. The moment I use the word extraordinary general meeting, that means it is something other than the annual general meeting. Now, for example, any meeting which is called for an urgent purpose, for some emergency, for some exigency, suddenly there is a death of a key management personnel. Suddenly some major changes are going to happen in the company. There is a default situation. There is a winding up. There is a major takeover. There is a merger. There is a pandemic. There is a disaster. Some kind of emergencies and exigencies that fall upon the company, and the company needs to take an urgent call on that. We call for the extraordinary general meeting. In the extraordinary general meeting, we try to go forward and convene it in such a manner with the board of directors to call the meeting, and we say that this will be on its own or on the requisition of the members, where we convey the idea saying that this is the reason why the company has called for, because of the particular reason. So we have decided to take this action altogether. So for example, there is a misconduct that happened, or there is some serious offense that has happened. The company is held liable for some unethical practices, or the company suddenly calls for a change in management. What they will do is that they will call the board of directors, they'll call the members on requisition, and they will conduct an extraordinary general meeting. You don't have to take a prior approval for it. The only thing is that the company secretary needs to be present. The minutes of the meetings have to be recorded and sent to the SEBI, so that you come to notify the public, the shareholders, very, very clearly what has happened and why this extraordinary general meeting came in place altogether. Now, the requisites for a valid meeting. What are the preconditions that are needed for a valid meeting? A meeting is said to be valid only to transact a business if it meets the following condition. The first condition is it is duly convened by a proper authority. Who is conducting the meeting? Who is giving the eligibility, the authorization to conduct the meeting? Who is the person who is going to tell that this is what you need to do? Proper notice must be served by the prescribed manner. So you should intimate the shareholders, the board of directors, the members, that this is how the meeting is going to be conducted. This is the date. This is the venue. All these things should be intimated well in advance. So the company has to convene the meeting only through a responsible person, an authorized person, who will send the notification to the members and to the shareholders saying that this is what is the meeting all about. The quorum must be present. That means you need to follow a protocol. You need to follow certain guidelines that have been prescribed by the company law, by the company act altogether. A chairperson must preside. That means the MD, CEO, chairman of the company should be definitely there for the meeting for whatever reasons, to address the query, to address the public, to understand the opinions, everything. A chairperson must be there. Minutes of the meetings must be kept. It's a due responsibility of the company secretary that each and every word that is being spoken in the company meeting has to be recorded, has to be kept as a record, and it has to be published within 30 days to the concerned authority and to all the people of the respective shareholders of the company. This is mandatory so that they make it a transparent effort in conveying the various functions of the organization. With this, we come to the conclusion of this session. I hope and believe that all the information shared through this session is of a great help and resource to you. In the upcoming sessions, we will be learning more about the various functions of the organization and how the company law is providing a greater guidance in terms of governance and activities for the organization. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me on this wonderful day.